I'm Lou Killian. After 26 years as a federal bankruptcy judge in the Northern District of Florida, I retired and became a mediator. I mediate commercial and bankruptcy cases throughout the state of Florida and the southeast United States. I'm certified by the Florida Supreme Court and have been trained as a bankruptcy mediator by the American Bankruptcy Institute.
Why did you decide to become a mediator?
Many times over my career on the bench, I asked the parties in contentious cases, why can't you settle this? Having me decide the matter was going to be costly, time-consuming, and full of uncertainty. As a judge sitting on the case, I was limited in how far I could go in helping them to negotiate a settlement. After I retired, I decided that as a mediator, I could do what I was unable to do from the bench.
Can you briefly explain the mediation process?
Mediation is a collaborative process in which a neutral third party endeavors to assist the parties in negotiating a resolution of their dispute. While the mediator facilitates the discussions, the process is driven by the parties, and they alone have the ability to determine the outcome of the dispute. Mediation affords the parties the opportunity to avoid the fees and costs of litigation, to end the dispute, and to avoid the risks of having someone else, either a judge or jury, decide the outcome. While a mediation that ends in settlement rarely leaves either side happy, they usually leave with a result that they can all live with.
How does your role as a mediator differ from being a judge?
Being a judge is much easier than being a mediator. As a judge, I would listen to the evidence, decide what the facts were, and make a decision at the end of the day based on the law and the facts. As a mediator, I do not decide anything. The parties make the decisions. My role is to assist them in coming up with a solution to the problem by helping them to identify their own true interests, assisting them in identifying the risks and weaknesses in their own cases and the other side's point of view, and trying to get them to focus on the future rather than the past. Even as a former judge, I cannot tell the parties how I think the case may be decided. However, my insights help me to ask probing questions which may help the parties to see the potential flaws in their own cases and the benefits of settlement.